I have 4 cases to tell you about today, all in the context of personal insolvency by way of a bite-sized update. The first case I'd like to discuss with you is Kilgee and Myers and Hartwell. This was a case concerning the circumstances in which a trustee in bankruptcy becomes aware of a bankrupt's interest in a property for the purposes of Section 283A(5). It is a matter of importance because, in my experience, a bankrupt is not always as forthcoming as he should be about his interest in the family home. And there is a limit to how much information a trustee can obtain from other sources in respect of interests which aren't registered at the land registry. The case was a High Court appeal from a decision of a deputy ICC judge. As we all know, Section 283A is the so-called use it or lose it provision in respect of real property. When operative, it gives the trustee 3 years in which to decide what to do about a bankrupt's interest in his home or the home of certain other people, such as his spouse. The issue here is whether that 3-year period had been exceeded, which raised the question as to the proper construction of Section 283A. Mrs. Kilgee was the bankrupt and a widow. Before his death, she and her husband had occupied the matrimonial home together for 20-odd years. It was registered in the sole name of the deceased. The trustee's view was that Mrs. Kilgee had a 5% beneficial interest in the property as a result of a common intention constructive trust. Mrs. Kilgee's position was that she had a larger interest. Mrs. Kilgee had completed her bankruptcy questionnaires for the OR and the trustee in the normal way. Her case was that she made it clear that she asserted a beneficial interest in the property. The trustee's case was that Mrs. Kilgee had expressly denied any interest in the property, whereas Mrs. Kilgee claimed that she had made her position clear in those documents.